A patient confesses to murder. That's quite the opener, isn't it?
It definitely grabs you.
Yeah, it speaks to accountability, right? And today, we're diving into a different kind of accountability, one involving nations, their debts, especially in international business.
Mm.
Think about it. A country piles up a huge debt, then suddenly has to answer for it in someone else's court. We've got a real, legal heavyweight match here. And it all went down in Hong Kong.
It's a really fascinating space,
Mhm.
where national sovereignty kind of bumps up against the basic need for fairness when countries act commercially.
Exactly. So this deep dive, it's going to unpack a specific legal fight. It's sort of a shortcut, really, to understanding a pretty tricky part of international law, all through a real case from Hong Kong's top court.
The court of final appeal.
Right. And for you, the learner listening in, maybe you want the key info without drowning in legalese. You like those aha moments when things click. Well, you're definitely in the right place.
We're essentially asking, when a country does business, should it get special treatment compared to, say, a private company if things go south?
That's the nub of it. The case itself revolves around unpaid debts owed by the Democratic Republic of Congo, the DRC, to a company from Sarajevo called Energo-Invest.
This actually goes way back to the 1980s. Energo-Invest built some pretty major infrastructure in the DRC. Hydroelectric stuff, power lines.
Okay.
And the key thing is the work was done, it was accepted. The fight isn't about whether they did the job. It's about getting paid.
Gotcha. So the money just didn't show up.
Well, not all of it. The debt eventually got passed on to an American firm, FG Hemisphere Associates FG. They're what you might call a distressed debt firm. They buy up debts, often from countries hoping to recover them.
And the setting for this whole drama, Hong Kong's courts.
Yep. And our analysis today, it's based on excerpts from that judgment, FACV 5, 6, and 7 of 2010. It's dense, but we'll pull out the essentials.
So our mission today is kind of twofold. First, what's the big legal question? Is it absolute state immunity in Hong Kong, meaning states just can't be sued, period?
Or is it restrictive immunity, which allows for exceptions, especially, when a state is acting commercially?
And second, what does all this mean within Hong Kong's unique setup, the whole one country, two systems thing?
Right. How does Hong Kong's legal system handle these international principles when it's operating under China, which, well, takes a different view on state immunity?
Okay, let's dive into how this debt mess even started. Where did it all begin?
So back in the 80s, Energo-Invest from Sarajevo, a part of Yugoslavia, then they build these power facilities in the DRC.
Big projects.
Big projects. And like we said, the judgment makes it clear. Work done, work accepted. No argument there.
So the DRC got the infrastructure, benefited its people, presumably, but the bill, that became the sticking point.
Pretty much. Funding came through credit agreements. You had the DRC government, its state power company, SND, Société Nationale d'Électricité, and Energo-Invest involved. They tried rescheduling payments, but ultimately, the DRC and SNDE defaulted. They just didn't meet their obligations.
With international deals like this, I'd expect some kind of dispute resolution plan baked in.
There was. Each agreement had an arbitration clause. International Chamber of Commerce rule, the ICC.
Ah, okay.
So in 2001, Energo-Invest kicked off arbitration against both the DRC and SNDE. Two separate arbitrations, actually, one in Paris, one in Zurich.
And those locations matter.
They do. Both France and Switzerland are signed up to the New York Convention on enforcing foreign arbitration awards. And crucially, that convention applies in Hong Kong, too.
So these weren't just informal chats. These were proper, legally recognized processes.
Absolutely. And interestingly, the DRC decided not to show up for the arbitration hearings. SNDE, the power company, did participate, though.
And the outcome?
Both tribunals ruled for Energo-Invest in 2003, awarded them big money, millions of US dollars against the DRC and SNDE, jointly and severally.
Meaning both were on the hook for the full amount.
Correct. And here's a key detail. Neither the DRC nor SNDE ever tried to challenge those awards in court, anywhere. They basically stood uncontested.
Energo-Invest wins legally, but still no cash, which is where FG Hemisphere steps in, right? Buying the debt.
Exactly. 2004, Energo-Invest assigns all the rights from those awards to FG. FG's whole business is investing in emerging markets, often by buying up this kind of distressed sovereign debt. These awards were basically their main asset.
Were the DRC and SNDE told about this handover?
Oh yes, they were formally notified.
Did that make them pay up?
Nope, not voluntarily. FG did manage to claw back a bit, just over $3 million, through enforcement actions in places like Belgium, Bermuda, South Africa.
A drop in the ocean compared to the total.
A tiny drop. By November 2010, FG was saying the DRC owed them almost $126 million US, principal plus interest, and that interest was racking up fast, about 30 grand a day.
Wow, an incredible sum. So how on earth does this fight between basically a debt collector and the DRC land in a Hong Kong court? This is where it gets really interesting.
The Hong Kong angle pops up in April 2008. A major company from mainland China, China Railway Group Ltd., listed in Hong Kong and Shanghai, we'll call them China Railway Parent, announces a deal with the DRC.
Okay, new player enters. What kind of deal?
It was a cooperation agreement leading to a joint venture, involved a Congolese state mining company, Gécamines,
Right.
an individual, Mr. Badika, and a group of Chinese companies, including China Railway's own subsidiaries based right there in Hong Kong. Let's call them the China Railway subsidiaries.
And because those subsidiaries are Hong Kong companies, they fall under Hong Kong law.
Precisely. They're separate legal entities in Hong Kong's system. Now, under this deal, if certain conditions were met, these Hong Kong subsidiaries were supposed to pay a huge entry fee, $221 million US to the DRC for a mining project.
Uh-huh. I think I see it now. FG, holding this massive unpaid judgment against the DRC, sees a potential pot of money about to flow through Hong Kong to the DRC.
Exactly right. FG saw its chance. They learned about this big payment and moved fast, filed what's called a unilateral or ex parte application in the Hong Kong High Court, got it in front of a Judge Saunders.
Ex parte, meaning FG made their case initially without the DRC even being there to argue back.
Correct. And in May 2008, Judge Saunders gave FG the green light, permission to enforce those arbitration awards against the DRC like they were local Hong Kong judgments.
Wow.
He also allowed them to serve the legal papers on the DRC overseas, and he issued a temporary injunction, basically froze $104 million of that entry fee payment from the China Railway subsidiaries, stopped the DRC from getting its hands on it.
A big move.
Yeah, and Saunders also set a date for a hearing on FG's main goal, appointing a receiver to actually collect that frozen money to pay off the debt.
So round one to FG, they got the money frozen, but you just know the DRC wasn't going to take that lying down.
No way. The DRC immediately applied to get Judge Saunders' order thrown out. That application went before a different judge, Judge Reyes. And Judge Reyes heard from everyone involved, FG, the DRC, the China Railway companies. In December 2008, he completely reversed Judge Saunders' decision.
Really? A total flip.
Total flip. Canceled the permission to serve the DRC overseas throughout the whole case against the DRC, and even ordered FG to pay the DRC's legal costs.
Ouch.
And later, he also dismissed the case against the China Railway companies and lifted the freeze on their money, too.
Why such a drastic change? What was Judge Reyes' reasoning?
His view was that the underlying deal, the mining project, the cooperation agreement, wasn't really commercial. He saw it as being about the DRC's economic development, its welfare, basically sovereign activity.
So protected by state immunity.
That was his take. Even if you applied restrictive immunity, he felt this deal fell under the sovereign umbrella. He also ruled that just because the DRC had agreed to arbitration in the original contracts didn't mean they'd waive their right to claim immunity in a court later on.
Interesting. So even though he seemed to lean towards restrictive immunity being the law in Hong Kong post-handover, he didn't think this specific deal counted as commercial.
That was his interpretation, yes. But FG, well, they weren't giving up yet. They took it upstairs.
To the Court of Appeal, right. And this is where we really see the split in legal thinking. The core conflict emerges.
Absolutely. Fast forward to February 2010. The Court of Appeal delivers its judgment. And it's a split decision, 2-1 in favor of FG.
Okay, so the majority sided with FG this time. What was their logic for overturning Judge Reyes?
The majority Vice President Stock and Justice Yuan, they argued that restrictive state immunity wasn't new to Hong Kong. They said it was already part of Hong Kong's common law.
Before the handover, even.
Yes, before and after the UK's State Immunity Act applied here, that act stopped applying after 1997, of course. So they brought back Judge Saunders' order, the one freezing the funds, and awarded costs to FG.
But they didn't just say FG wins, collect the money.
No, they sent it back down to the High Court for more investigation. Specifically, they wanted inquiries into two things. Was that $221 million entry fee actually the DRC's asset? And importantly, was a big chunk of it earmarked by the DRC for Gécamines, the mining company, for purely commercial or private activities, not state functions?
Got it. And the judge who disagreed, the dissenting voice.
That was Justice Young. He had a fundamentally different perspective. He wasn't convinced that restrictive immunity was like settled customary international law yet. And more critically, He believed Hong Kong, being part of China, had to follow the mainland's approach, which is
Absolute immunity.
right. So in his view, the DRC should get full immunity in Hong Kong courts. But interestingly, the whole Court of Appeal, all three judges, agreed on one point. The DRC hadn't waived immunity just by agreeing to arbitration way back when.
Okay, so a clear division in the Court of Appeal. It really tees up the final showdown at the Court of Final Appeal, highlighting this fundamental clash, absolute versus restrictive immunity in Hong Kong.
Precisely. And Judge Chung, writing the judgment for the top court, the Court of Final Appeal, nails this right at the start. He says the central issue is, what kind of state immunity do we have in Hong Kong courts? Is it absolute total protection or restrictive with that key exception for commercial deals?
He must have acknowledged the tension there.
Oh, yeah. He points out this push and pull. On one side, you need to respect state independence. On the other, you need fairness for people or companies doing business with states.
It's that classic balancing act in international law. States need breathing room for government stuff, sure, but if they're playing in the commercial sandbox, shouldn't they follow the same rules?
That's the heart of it. Judge Chung actually quotes an old case saying sovereign immunity is basically a detour from the normal path of justice, so you only grant it when it's really clear-cut.
Okay.
But he also contrasts that with another principle from the Lotus case, basically saying you don't just assume limits on a state's independence lightly.
So weighing these competing ideas very carefully, and of course he had to factor in Hong Kong's own rulebook, the Basic Law.
Absolutely critical. The judgment digs into several key basic law articles. Article 8, about continuing the pre-handover laws. Article 13, on the Central People's Government handling foreign affairs.
Right.
Article 19, about Hong Kong's independent judicial power, including final appeals. And Article 158, which gives the Standing Committee of the National People's Congress, the NPCSC, the power to interpret the Basic Law.
And the various sides in the case use these articles to argue their points about immunity.
You bet. The DRC, the China Railway Companies, and importantly, the Secretary for Justice, acting as an intervener for the Hong Kong government's view, they all argued the court should ask the NPCSC for an interpretation under Article 158.3.
On how these basic law bits apply to state immunity.
Exactly. And they also floated the idea of getting a certificate from the chief executive under Article 19.3 about whether these were acts of state.
Acts of state, like core government functions that courts usually don't second-guess.
That kind of thing.
Yeah.
And to bolster this, the Secretary for Justice presented letters from the PRC's Ministry of Foreign Affairs office in Hong Kong.
What did those say?
They laid out Beijing's position very clearly. China consistently follows absolute state immunity, never adopted restrictive immunity.
So, a clear message from the central government. Absolute immunity should apply in Hong Kong, too. But wasn't there a potential wrinkle? Something about a UN convention?
Yes, a very significant one. The judgment points out that China actually signed the 2004 UN Convention on jurisdictional immunities of states and their property.
And that convention recognizes restrictive immunity.
It does, which seems contradictory, right? So a second letter tried to explain this. It said China signed to support international efforts, but crucially hasn't ratified it. And it doubled down. China remains committed to absolute immunity.
Okay.
Then a third letter sent directly to the Court of Final Appeal hammered this home again, stating Beijing's absolute immunity stance applied to Hong Kong.
Sounds like a complex diplomatic dance. Meanwhile, FG must have been arguing the opposite. Maybe that absolute immunity in business deals just isn't fair?
Pretty much. They argued it clashed with the basic principle of pacta sunt servanda agreements must be kept. You know, if a state makes a commercial promise, it should honor it.
Makes sense. How did the government lawyer respond to that?
The Secretary for Justice countered that immunity is about procedure. Can you even sue the state? Not about the underlying substance of whether the agreement is valid. So immunity doesn't necessarily undermine the agreement itself, just the ability to enforce it in that specific court.
So the Court of Final Appeal is facing this. Beijing's clear preference for absolute immunity, international trends leaning restrictive, Hong Kong's own legal history, and the Basic Law. What did they decide about asking Beijing for interpretation?
This is a huge moment. They decided not to seek an interpretation from the NPCSC or guidance from the executive.
Really? They decided they could figure it out themselves.
Yes. In a powerful statement on judicial independence under one country, two systems, they basically said it's the court's job to say what the law is. They even quoted the famous U.S. case, Marbury v. Madison.
It is emphatically the province and duty of the Judicial Department to say what the law is.
Wow. So they asserted their power to interpret the law on immunity for Hong Kong.
Absolutely. Their reasoning was that deciding if restrictive immunity applies is a common law question. And Hong Kong's common law before the 1997 handover clearly included restrictive immunity. They pointed to a key case, the Philippine Admiral.
Okay.
Plus, they said Article 8 of the Basic Law is specifically there to ensure that pre-existing legal system continued.
So the logic was, we had restrictive immunity. The Basic Law says continue the old system. Therefore, restrictive immunity is the law here, and we, the court, will determine that. That really shows the two systems part in action.
Precisely. The judgment tackled the one country, two systems idea head on. It drew a distinction, matters of recognizing states like, is this entity a country that falls under national affairs handled by Beijing?
Right.
But the question of immunity, absolute or restrictive, that relates to Hong Kong's legal system, and that, the court said, is for the Hong Kong judiciary to decide independently. Did they address the potential political fallout? The idea that this might clash with Beijing's policy or cause embarrassment?
They did. They rejected the argument that sticking with restrictive immunity would somehow threaten China's sovereignty or cause problems. They argued the rule of law actually serves sovereignty.
Interesting perspective.
And they said making this decision would actually showcase the vitality, the strength of one country, two systems. They even pointed back to older Hong Kong cases and Privy Council appeals from Hong Kong that had already dealt with restrictive immunity and confirmed the court's independent role.
So they felt they were on solid legal ground based on Hong Kong's own history.
Yes, and they distinguished this case from others, where courts might defer to the government, like cases purely about recognizing foreign governments or deciding territorial claims. This was about immunity from suit for commercial acts. Different kettle to fish.
Okay, so after wading through all that, the debt, the arbitration, the different court levels, the basic law, the signals from Beijing, what was the final definitive ruling from the Court of Final Appeal on state immunity?
The Court of Final Appeal ruled unequivocally. Restrictive state immunity is the law in Hong Kong. Meaning foreign states can be sued in Hong Kong courts if the lawsuit stems from their commercial activities.
Right.
They don't get blanket immunity for business deals.
So FG Hemisphere, the company holding the DRC's debt, ultimately won on the core legal principle. Wow. This deep dive has really covered some ground: international debt, big business deals, complex constitutional law. So what's the big takeaway for you, the listener?
I think the absolute key point is Hong Kong courts apply restrictive state immunity. That's the rule.
Right.
In this case, it really throws a spotlight on that constant balancing act respecting state sovereignty while demanding fairness in global commerce. But maybe even more importantly, it's a concrete example of one country, two systems at work. It shows Hong Kong's judiciary acting independently to interpret and apply commercial law principles, even when they touch on sensitive international issues and differ from the approach on the mainland. It connects this abstract legal idea to the reality of global business and Hong Kong's specific place in it. That's the aha moment, I think.
Yeah, definitely. It's where law, global politics, and Hong Kong's unique status all collide, which leaves us with a bit of a provocative thought to chew on, doesn't it? Well, given China's stated policy is absolute immunity, and Hong Kong has now firmly landed on restrictive immunity, what happens down the road? Could we see tricky situations or maybe new kinds of arrangements emerge in cross-border business disputes that involve state companies and assets flowing through Hong Kong?
That's a really good question. It's certainly something to watch. The complexities of international law and how different legal systems mesh or don't in our globalized world, well, they keep throwing up new challenges. This case gives us a really valuable lens to look at those future developments.